So let's look at the integration of ADR and formal court procedures. Now, keep in mind, certain actions don't go to arbitration. Titles to real estate, equity issues, that's issues like specific performance, temporary restraining orders, that sort of thing. But there's a difference between court-annexed arbitration and voluntary arbitration. And certainly it's the reviewability of the award. But what's the role of the arbitrator? The role of the arbitrator is essentially the same. Okay, remember, we got He-Man and his panel, and this beach bunny. I don't like the beach bunny. But anyway, their role is still the same. They're not attorneys. They're not judges. At least they don't have to be. Okay? But what rules apply? Well, generally that's going to depend on the state. Okay? But let's talk about waiver again. Once a court directs that a dispute is to be submitted to a court-annexed arbitration, the parties must proceed to the arbitration. That's the court saying, okay, listen, you're going to go and you're going to do this. Alright? So obviously if the court says something, you have to do it, otherwise you're in contempt. Alright? If they fail to appear, so if BM or Leonardo don't show up for arbitration, that's a waiver, and it constitutes the right to reject the award. Okay? They no longer have the right to reject, because they didn't show up. Okay? Court-related mediation. Right? Mediation is becoming more and more popular. Right? It's used on business issues. As y'all, get out of school, you may end up going to some of these mediations. We have this thing called a summary jury trial. This is a mock trial that occurs in a courtroom before a judge and a jury. But the jury's verdict is only advisory. Right? We also have forms and services. There's nonprofit organizations and for-profit organizations. Right? AAA, American Arbitration Association. Right? They charge a fee for their services, but certainly it's a nonprofit. For-profit organizations, an example would be JAMS In Dispute. This is the leading firm in the private system of justice. And they're usually quicker, because obviously they're for-profit. We also have online dispute resolution, relatively a new idea. But they commonly involve disagreements to the rights of domain names, the www.whatever.coms. That's property. Okay? That's ownership. And so generally we'll do this online dispute resolution to say who actually owns that domain name. Negotiation and mediation services. Generally they're more practical than litigation, and they're done online. Okay? Arbitration. Even AAA offers some arbitration programs online. We also have international dispute resolution. All right? Forum selection and choice of law clauses designate the jurisdiction in which the dispute, in which the dispute arising under the contract will be litigated, and the nation's law that will be applied. Similar to conflicts of law and choice of law provisions in just a regular American contract. Arbitration clauses, you'll see these a lot in all sorts of contracts. But usually they have this clause also in an international clause, meaning that before they go to litigation, they'll go to arbitration.